All right, hello everybody. Welcome back to another Coffee with Michael. I have the tried and true Renee Noy with me. Renee is a founding partner from Workwise Law. She is just such a great source of information. I'm not going to go into her whole bio because I've done that so many times, and I think most of you know her by now, if not all of you. So Renee, welcome.
Thank you. Thank you.
We don't have a lot of time with Renee today, so we're going to get through a few things. Today's topics really are just employee relations scenarios because I get really interesting emails and calls from all of you, which I love. And the most fun thing is when I get to talk to the DLSE or I get to call someone like Renee and I ask her this question and I stump them. So I don't feel so bad after that. So the first one I want to go on it has to do with a disability. And so I'm going to read you most of what I got from somebody. It's somebody needed guidance on an employee who is under 90 days and a disability. So this employee is deaf and who has since day one been counterproductive and constantly in the HR office and supervisor's office and or in his presence, either complaining or making continuous non-productive meetings, which have required us to unfortunately take more than the necessary time to continue our production and his continuous training to the level of interruptions through the days since his hire date. We have had some problems with the quantity of work more recently, and today he requested another meeting about his concerns about how the department is run. The company is concerned that his productivity is more focused on the way the company is being run due to the ongoing meetings he asks to have or recommendations and ongoing requests he has made in the last 30 days. He is not productive. I know how this works, but can you give us some options on how to handle this so that we stay in compliance and not put any liability in jeopardy if the company would terminate? I understand that even if the employer is at an at-will company and this employee is under 90 days, would still require the company to give reasonable reasons for termination. But how could we best address this? So there's a lot in there, but what was really interesting to me is this comes up still regularly. And it is, again, all operations, right? Well, this person is under 90 days, so we could just fire the person and we don't have to tell them anything. In fact, some employers still think that just because they're at will, that no matter how long the employee is with them, they can just fire them and they're off scot clean. So let's talk about that first. What truly is at will?
I just said yesterday to a client because they called me and said the exact same thing. They said, well, I can fire them because it's at will. It's not will employee. And I always say if at will meant at will, I'd be on food stamps. Have no work.
Yeah.
At will is just a fiction. I mean, it's true that we are an at will state. That is a true statement. And that does mean that you are allowed to fire for any reason at any time, and they can leave for any reason at any time if they're there at your will.
But you just said it there. For any reason.
For any reason.
For
But
any
here's the
reason.
caveat, the big
Yeah.
giant asterisk that's with
Yeah.
that comes with this is unless it's for a protected reason. So if an employee is in a protected class, which obviously this person is deaf, so that puts him into a protected class by itself. The other thing that you may not think of that puts him into a protected class is the fact that he's making complaints. So when you make a complaint about the company and it's a good faith complaint, which good faith is a very loose term because it just means they're not maliciously trying to do something just for the purpose of getting somebody else in trouble. So if they're making a good faith complaint about productivity, about work safety, about health, wages, anything, then that puts them into a protected class because now they've engaged in this protected activity of making a good faith complaint and he's hearing impaired. So you have these two factors. So if you just terminate him and what he'll do is he'll go to his plaintiff's lawyer and he'll say, I was terminated, and the lawyer sees that he has a disability. And then when he says, well, why were you terminated? He's not going to tell the lawyer, oh, it's because I wasn't productive, in the operations room. It's because I was making all these complaints and you're basically a whistleblower. And now you are in a wrongful termination lawsuit for all of these protected activities that he engaged in. So at will does not mean at will. At will means that, yes, you could terminate if it's justifiable. And the only way to really make it justifiable is if you have documentation to show that it's because he's not productive on when he's working, that he's not doing his job, he has an attitude. Those are legitimate reasons to terminate somebody. But again, with the being deaf, you do need to make some accommodations based on whatever the doctor tells you the accommodations need to be. So if he's not working as fast as somebody who's hearing, but it's because of his hearing impairment, that's relevant. So now you can't terminate based on that. You might have to create an accommodation for him.
All right. This one scenario has so many things thrown in there. So let's talk about the employee that is constantly complaining and having all these meetings on non-immediate work-related things. So it has nothing to do with his or her specific training not happening, or that they're struggling with with whatever. They think they have better ideas on big picture company, how it should be run. So whistleblower, everybody thinks they're a whistleblower, right? But a whistleblower, in my mind, was always somebody that was, coming to complain about something that was a legal issue, a safety issue, a hazard, something was going on, somebody was being treated badly, potentially a legal issue. But if somebody is coming back and just saying, well, I think you guys are stupid because you're not running the company the way I would, and he's a new employee. At what point does somebody become a whistleblower? And how would you handle an employee that just likes to complain?
So, I mean, that's human nature, right? Most people do complain. It's very much part of, the human experience. So it's tough. And so if it's truly not, I mean, you really have to figure out how to differentiate a good faith like work concern versus just like I have, an overview of how I think you should run a company if I were the CEO, and the person who's the CEO is like, I really don't care what your opinions are. I just want you to do the work. That's tough. So you have to make sure that what the complaints are about are not something that would be considered protected. It wouldn't be like a good faith complaint about something that's, could have harmed the safety of him or the others, or, wage issues, anything like that. So if it's just complaining for the purpose of complaining, then you still need to take it seriously, and you still need to let him talk. But you can also kind of like try to redirect the conversation and say, listen, I really, really appreciate that you're bringing all of this to our attention. We will note all of this. We'll, take all this into consideration, but we expect you to do X amount of hours of work every day. We expect this amount of widgets to be produced every day, whatever the case may be, and you're falling short. And I think it's because you're spending way too much time in here talking to us about how we should be running our business. As much as we appreciate, that you care and that you're concerned, we really need you to focus on the tasks that we're giving you, that we're paying you for. And if he comes back the next day with some, just completely pointless complaint that really has, again, nothing to do with the safety or health or whatever of the employees or the workplace, then again, just say, listen, I need you to go back to your workstation. If you want to write out an email or, we could set aside, Friday for an hour, whatever. But right now you need to go back to your work. So you need to just constantly like redirect it. But whenever any employee comes to talk about anything, I wouldn't just shut them down. I think that's dangerous because you do want to know what they have to say. And you don't listen to them. I always say they'll find a lawyer to listen to them, and you don't want your employees going and finding lawyers. It's like the worst thing.
Yeah, those lawyers, man, can't trust.
The worst. The worst.
Okay, so again, all these things are again, it seems like common sense, but we do let frustration get the better of us sometimes, right? The boy who cried wolf. It's like, but at some point there's actually a wolf. And I have known individuals, they didn't know how to really bring up what was really bothering them. And so they started with something which you may deem silly, or is not really relative to what they need to be doing, but that is their way of coming in. So I think a lot of times, I mean, and what do you think would be, like a good question? It's like you're bringing up these things, they don't seem to have really an immediate impact on your position. Is there something else? I've always been a big proponent of this, direct questions. Is there something else? And then you get to document it, because at least if they try to come back and say that there was a big issue, they say, well, nobody did anything about it. You can at least go back to your documentation. And so that, I asked this direct question, and they, answered negatively, or in the negative, that no, there was nothing else going on. So what are some other tips to get them back on track? Because this is something where I talk to a lot of our HR managers, and the people who are getting this right now. I know that they say, yeah, we do this all the time, but at what point is enough as well? So good question. What's a good question to try to help you with your risk and liability, and how can we get the employee back on track or take that step when, this may just not be a good fit?
Yeah, I mean, if they're coming in on a daily basis and just like complaining, and it's not really anything that you need to be concerned about, I agree. I'm all about direct questions also. Just say, is there anything else going on? Is anybody, affecting your ability to do the work? Is there something going on with you? Like, just really try to get to the heart of the matter. And if he's like, no, I just don't really feel like, that you guys are doing it the best that you can. I think I could bring more revenue into the company. Just say, you know what, thank you. Right now, I need you to go back to work. And then eventually, if this happens again or, a third time, write them up. And eventually that could lead to termination. And as long as it's not again, this whole good faith complaint aspect of it, as long as it's just like them just really just wasting time in your office for no good reason, and you've kind of established that, you can terminate for that. They need to be there. You're not paying them to sit there and tell you how to rework your company. You're paying them so that they can actually do the work.
So, and again, I know there's no bright line, right? Where if they do this many times and you go to this step, then this is the next step. But I think, three strikes and you're out is a fairly good way, and not so much out, but these complaints, if they're wasting time, I think after the third one, within a couple of weeks, right? Because they can be up to an hour sometimes. You're thinking, you know what? We've had this conversation, and you have to at some point show that you are serious. So maybe at that point of formal, after the third one, it's like, you know what, we talked about this. I need you to focus on this. But what is some good language to use? I again, you're wasting my time is maybe true, but it may not be the nicest thing to say because you want to encourage them to come to you with things. What's some other language that
I,
employers could use?
I would just say, thank you so much for bringing this to my attention. Thank you so much for caring about the company and wanting it to be better. But it's affecting your productivity, the amount of times that you're coming into the office. I need you to do your work and you're not doing it. And so I'm going to have to write you up this time, for not being productive and not, focusing your attention on what we're paying you to do. And that's it. I mean, I wouldn't say you're wasting my time to anybody, but you just, it's always, if you're focusing always on performance, like if it always comes down to like I need you to be performing the tasks of this job, to justify, the paycheck that you're getting every 2 weeks. That's a really good way to have it documented, so that if there's a termination, we can always say, look, this had nothing to do with anything other than his lack of performance and his shortcomings in his performance. And he was coming into the office and, going to report to work. Everyone's at their station. He's in my office every single day complaining about, things that are just, they're not anything that, are worthy of us having to fix or deal with. And he was just complaining, and we really think it was just wasting time. And it's, we needed somebody to be there to be doing the work.
So, and I know you wouldn't tell somebody that they're wasting your time. I certainly wouldn't either. But I know a lot of people in operations that would, and they wouldn't think
Well,
they wouldn't
it's
mind for that.
annoying.
And so it's a way for HR managers to help coach their managers and supervisors on how best to communicate with employees. But so as far as pulling the trigger and really just okay, it's termination mode. I do believe that under the 90 days would have a different length of runway than you would outside that window, right? Because right at this point, you're really trying to determine whether this person is a good fit. So if you go through and maybe after two times, the person is making all these requests, then I would maybe right or wrong, I would probably recommend the employer quickly, all right, get that formal document in that, look, you're not doing what you need to do. And then if it happens again, then it's like, you know what, this may just not be a good fit. But if the person has been there 6, 7, 8 months and you've been allowing this to happen, or maybe it hasn't been as big of a problem, but now it's kind of ramped up, then you give them a little bit more grace, a little bit more of a runway to correct that issue. And plus, if it's happening after a longer period of time, there may be other issues involved. So you want to take your time and really try to dig in to find out if there's something else that's generating this. What are your thoughts on that? How wrong
Yeah.
am I?
No, you're not wrong at all. I mean, I agree with you. So, it's so funny that it's not wrong. Funny is not the right word, but it's interesting how people get so stuck on this probationary period. And so if
Yeah.
it's 60 days, 90 days, 30 days, whatever it is, and I get calls all the time from clients and they're like, okay, we're at day 89. We're really not sure. We think we want to terminate. But I always tell them your liability at 89 days versus 94 days versus 2 days is
Yeah.
essentially the same. Because you could still sue for wrongful termination. And I've had full-blown litigations for somebody who's worked for a company for 5 days. So just because you cut it, there's pros and cons to both, because you always want to give ample warning and ample time for them to like turn it around and give them, that ability to fix whatever is going on. But the longer they work for you, like if you have a 20-year employee, I mean, I just finished a litigation. I did a mediation about a week ago for an employee who worked for the company for 21 years. This woman was a nightmare, and she was like problem after problem after problem, but the owner just didn't want to deal and just kept giving her all these allowances. And all of a sudden, finally, after 21 years, she's like, I can't take it anymore. And she fired her. Well, that case has so much value
Mhm.
because, in 20, and, of course, the mediator's like, well, where are the write-ups? Where are the performance improvement plans? Where's all the, the evaluations? And there was nothing. It was all verbal, which you can't prove. So, that's tough. That's 21 years you give to your life to a company. Alternatively, you work for somewhere, a few days and you fire them because you just see the writing on the wall. And now it's like, well, look at the, I moved for this job, or I quit my other incredible job for this job and this opportunity. And it's like, it's never, it's never easy for an employer because you have to weigh it all out. But I agree with what you said, Michael, that if, at day 80, this guy is like in your office, once a week and just wasting your time for hours on hours, and you've kind of like let them know this is not really okay, and then you terminate them, if there's something written down saying, please start focusing on your work, you're not being productive, that's a lot better than 6 months down the road. All of a sudden, you're like, oh my gosh, I cannot listen to this guy complain anymore. Meanwhile, nothing is documented. So everything was perfect. 6 months, he's fired. You never want to blindside your employees ever when you terminate. And, anyone who ever calls me and says, okay, I'm ready to terminate somebody, my first question always is what's documented. And if they say, oh no, nothing, but don't worry, Renee, I've talked to this guy 10 times. Like, I'm like, no, if you talk to, like, yes, he probably won't be blindsided if you talk to him 10 times. But if you
Yeah.
don't have anything written and then he goes and says, I was the best employee that's ever lived, and I just out of nowhere one day I come in and they fired me, that's not going to go well for you.
Yeah. All right. So let's jump now to employees who are giving their notice. Because this has come up. I mean, this comes up regularly. I'm not sure if you've ever received this, but let's say you have an employee who gives you notice, maybe 2 weeks, maybe 2 months, right? Employees that give you 2 months are either really great employees who have shown that they've been good employees and care about you and they want to make sure that you can replace them. Or it's a horrible employee. They're giving you 2 months because they're just going to be out looking, right?
Right.
And they can have something on. So, um, what are the do's and don'ts? If an employer wants to go ahead and just say, you know what, thank you very much, we're going to accept your resignation immediately. Can that be done? What are the pitfalls in that? You have to pay an employee out uh, for the notice they gave you. What are some of the things to look at?
Okay. So if an employee says to you, I'm giving you my 2 weeks, I mean, as soon as an employee resigns, unless they were like what you're describing as like this great employee that has just been doing wonderful and now they're moving to New York. And so they had to give you notice, like that's fine. Then let them transition out. Let me see if they're even willing to train the new person. That's to or help hire them, whatever. That's fine. But if an employee who's already been a problem employee, they finally resign and they say, don't worry, I'm going to give you a month, trust me, you don't want that person in your office for a month because they can either download every document that you've ever had on your system. They can completely sabotage the company. They could reach out to your clients and say, oh, by the way, I'm leaving, come to me at this new company. There's so much time and space and autonomy for them to just, completely destroy your business or hurt it. I don't, once an employee tells you that they don't want to be there anymore, you want to get rid of them. The problem is that if, let's say, they give you 2 weeks notice, you're like, you know what? Actually, today's your last day. Go clear out your desk, and you cut them off the system. You just converted that resignation to a termination, which is problematic for two reasons. First of all, now they're entitled to unemployment. So that's, which is not a huge concern because it's, that's, you have insurance for all that, but you do now have to pay out unemployment. And secondly, you've just made it a lot easier for them to bring a wrongful termination case against you versus if they resign and then it's a constructive termination, which is the only way you can do a wrongful termination from a resignation, because they're saying you made my life and job so impossible that basically you effectively terminated me. That's constructive termination. that's a hurdle to get through when you're dealing with a wrongful termination case. It's much harder to bring a wrongful termination based on a resignation versus a termination. So you've kind of created a much easier way, a path for them to go find a lawsuit against you. So what the best scenario is, if they say, I'm giving you 2 weeks notice, say, you know what? Thank you so much. Your last day will be in 2 weeks from today. Don't need to come back into the office. We'll pay you out for the next 2 weeks and keep them on the payroll cycle, cut them off the system. They're removed as an employee, but their last day is in 2 weeks from now. Then you're preserving the resignation status, but you don't have to have them in the office. So that would be the best case. But if you're like, you know what, I don't want to deal with this person. If you have everything documented, this person, was problematic, but you have it all written down and you move up their resignation, turn into a termination, it's better to do that than leave them in the office for an extended amount of time.
So if you're going to pay them out for that amount, then would it be possible to say, look, again, the negotiation, we're going to accept the resignation immediately. We will pay you out these 2 weeks if you sign, if you sign a severance agreement. Is that something that's doable? I mean, if you're going to pay them out anyway.
So I had a lawsuit like that, and that's exactly what happened. And then she ended up suing and saying that it was coercion and that was basically a way of terminating her. So it would end up settling. So who knows what would have happened if this actually, was in front of a jury. But any risky termination, resignation, I always suggest severance. But there's two. I mean, that's a whole other podcast because severance is so complicated. Because on one hand, if they sign the severance, they sign the release, you're good. You don't have to worry anymore. On the other hand, if somebody resigns and you're like, well, here, you know what? Let's make today your last day. Here's a severance agreement. So, and we'll preserve the resignation, but here's a severance. And also you throw $10,000 in front of them. First of all, it says in the severance agreement that they should talk to a lawyer. I get calls all the time, like many times a week, to review people's severance agreements. And and when I'm doing it for the employee, I'll say, oh, well, let's talk about this. Because a lot of times it looks like they're fearful. And so why are they throwing $10,000 at you? So now it's like, well, maybe I'll go assert my rights and see if I can get more out of you. So I'm literally dealing with that right now, where we threw $25,000 at this guy, and it was such a justified termination. He went and got a lawyer, and before the day that the severance needed to be signed at the 21-day mark, we got a letter from the lawyer. So it's such a lose-lose, to be honest, when you're in California as an employer. It's so difficult.
So pay the 2 weeks and just don't let them come back in.
So
You're getting off easy. Yeah. But what if they give you 2 months notice?
Yeah, I mean, it's at some point, it's really just a cost benefit analysis that you have to do, how risk averse versus risk, tolerant you are. And if you're like, you know what, I can't stomach this guy being in the office for 2 more months, but I also don't want to pay him out 2 more months. At that point, you may just want to convert it to a termination and, just hold your breath and either do a severance or hope that he doesn't sue you. But I mean, that's a big amount of time. But if it's worth it, if obviously everyone's finances are different. If it's worth it to you to just pay this guy out for 2 more months so you don't have to deal with him again, then do that.
All right. Well, we could go on forever on this kind of stuff.
Yeah.
All righty. So employee relations, if you're watching this, then you know that there's no black and white. There's so much gray in all of these things. Number two, train your supervisors. More importantly, train the management team. More importantly, train your C-level management team about the language to use. They think, well, I'm this. I can say whatever I want. And you can. Absolutely they can. But it brings risk. Because I love Renee. I have referred her to so many people. If you need something, call her. But I hope you don't need to call her. But Renee, any last minute pearls of wisdom?
Yeah, well, I like what you just said about training your managers, training the C-suite. That was something that I was dealing with all day yesterday with I have a very big client with thousands of employees, and they have this huge layer of just supervisors. And I saw the text message from the C-suite guy to the supervisor and all it said was, go talk to this employee about getting the updated doctor's note because their restrictions ended yesterday. We don't have an updated note. That's all it said. Supervisor wrote a text to the employee that said, you can't work here anymore. It was It's like, and he thought he was conveying the same message, and now we're embroiled in a lawsuit. And it's so frustrating because I've trained them so well,
Yeah.
leaving them to train them, the supervisors, and there was just something amiss. And so I'm like, we're now rescheduling all this stuff to do the proper training of the supervisors. But like, if anyone who's dealing with the employees, if they don't know all of these rules, you're just opening yourself up to so much potential liability. It's like the training aspect of this, and I know, Michael, that's your passion, is training.
Yeah.
But the training part is it's critical. It's absolutely critical. So that
Yeah.
that would be my takeaway.
Yeah, and thank you very, very much for saying that because yeah, this is the year people need to take part of their budget and put it back into training. Employees have gotten so tough to deal with in a lot of aspects. I don't see it getting any better for a number of years. So the more you can train your supervisors on responding the right way, we're all going to react, frustrated, angry, whatever, but how you respond is a critical part of them. So all right. So thank you very much for your time. I will get you back on here when we can spend, 2, 3 hours or something. But have a great rest of the week. Thank you very much, Renee. We'll talk soon.
Thank you, Michael.